Hello everyone, this video is going to be very interesting. We are going to study about CA Final Self-Paced Online Modules Set C. In this video, we are not going to cover any theory topic. Here we will be seeing practical case laws which will help us understand certain concepts in arbitration which are a little bit confusing and overlapping. But with the help of these case laws, we will be able to understand it very easily. So, stick to the end of this video. You will learn more about arbitration and your concepts will be very strengthened and strong. We are going to cover two case laws in this video, Balco versus Kaiser Aluminium and PISL Wind Solutions versus GE Power Conversion. These two are very important case laws in Arbitration Act. First, let us see about the Balco case law. Here, we are going to see about the Bharat Aluminium versus Kaiser Aluminium Technical Service case law. This was, the final judgment was given in 2012. So, we have to read this case law by case law. The final judgment in this case law was given in 2012. Therefore, while reading this case law, we have to keep in mind the law at that time. At 2012, what was the law? That should be in our mind while reading this case law. First, we can read the facts of the case. Facts was, the parties had a written agreement. These two are the parties, Bharat Aluminium versus Kaiser Aluminium. Bharat Aluminium is an Indian company and Kaiser Aluminium, it is an American company. So, here we can see that the concept is going to an international arbitration. They had a written agreement which included an arbitration clause. The agreement specified London as the venue for arbitration and the governing law was English law. So, we have the concept of seat of arbitration also included. A dispute arose between parties when Balco initiated arbitration proceedings in London. As per the agreement, in London we started the proceedings. However, there was a disagreement over the appointment of arbitrator. Which arbitrator we have to appoint? There was a disagreement. So, what the Balco is doing? It is filing an application before the Delhi High Court. Okay. Now, since the venue is in London, the case should be filed in London only. But Balco is filing in India. Why it is filing in India? It is saying that the Indian courts had jurisdiction. Why they have jurisdiction? Since one of the parties is an Indian company. They are telling that we can file a case in India, even though the seat of arbitration was designated as London. First, for understanding this, we need to know what are the types of arbitration. What is domestic arbitration? What is international arbitration? What is an arbitral award? And what is the seat of arbitration? For these, we are going to refer to the concepts. First, we are going to see what is an international commercial arbitration. By seeing this, we can automatically understand what is a domestic arbitration. What is given in the definition is that it is an arbitration relating to disputes arising out of legal relationship, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is. This is the important point, where at least one of the parties is. That means at least one of the party should be. He should be an individual. If it is an individual, he should be a national or habitually resident in a country outside India. If the one of the party is body corporate, it should be incorporated outside India, in any country other than India. If it is an association or a body of individuals, it should be managed and controlled outside India. If it is a government, it should be a government of foreign country. At least one of the party must be foreign. This is the simple concept that they are going to tell here. If it is an individual, he should be outside India. Body corporate, outside India incorporation. Association, management outside India. Government of foreign country. So, where at least one of the parties is foreign, it is called as an international commercial arbitration. In short, we can call it international arbitration. So, by reading this definition, we can understand that when both of the parties are Indian, then we can say that it is a domestic arbitration. The express definition is given for international arbitration. One of the parties should be foreign. Both are Indian parties, it is a domestic arbitration. Now, we can go to the next section. The next section we are going to see is section 2, subsection 2. Part 1 of the Arbitration Act shall apply where the place of arbitration is in India. Where the place of arbitration is in India, only then we can apply the part 1. Here we are seeing the part 1 of the Arbitration Act. Part 2 is for enforcement of foreign awards. Part 1 is named as just arbitration and it will apply where the place of arbitration is in India. Place here refers to the seat of the arbitration. Now we have a question. What is the seat of arbitration? For that we have to refer to a concept for seat of arbitration. What is a seat of arbitration? Seat of arbitration is a legal place of the arbitration. It will determine the law applicable to the arbitration. For example, if the seat of arbitration is United States of America, then the arbitration will be conducted according to the United States law. If the seat of arbitration is in India, then the arbitration will be conducted according to India law. So this is the concept of seat of arbitration. Mainly it will determine the law applicable to the arbitration, including the procedural aspects. Even the procedure will be as per that law only. Now we can see in the study material what is given for the seat of arbitration. In the study material, it is also given the legal place of arbitration and it will determine the applicable law for the arbitration, including the procedure. The principal civil court will have the jurisdiction and they will provide the assistance through supportive measures. What is supportive measure? For example, you will be going to get section 9 interim measures. Under section 9, you will be getting interim measures from a court. For this, which court you have to go? Whether the Indian court or United States court. Where in the problem of international arbitration, this is a very important thing. Under which court you have to go and get the measure. This is a problem, and for this, the solution is the seat of arbitration. The principal civil courts of the seat of arbitration will provide the assistance. For example, if the seat of arbitration is United States of America, for getting interim measure, you have to go to the USA court. But if the seat of arbitration is in India, you can go to Indian court for getting the interim measure. So, this is the importance of seat of arbitration in getting interim measures. Now we understood the concept of the seat of arbitration. Here the place of arbitration refers to the seat of arbitration. Here there is a proviso. This was inserted in 2015. So we need not read this for understanding the Balco judgment. So I am not reading this proviso. Now we can see what are the issues involved in this case. What is meant by the place of arbitration in section 2, subsection 2 and section 20. What is the meaning of place? That is they are asking. What is the meaning of words under the law of which the award is passed under section 48. Does section 2, subsection 2 bar the application of part 1 to arbitration where the place is outside India? Does part 1 apply at all stages of arbitration, that is pre, during and post the proceedings, except for the areas specifically falling under part 2 and part 3? Whether a suit for preservation of assets pending in arbitration proceedings is maintainable? These are the questions asked in the arbitration case for Bharat Aluminium Company versus Kaiser Aluminium and Company. Now, what are the observations of the court? What is the judgment of the court? What are the decisions made by the court? That we are going to see. Supreme Court says that the term place or venue, it is the seat of the arbitration. That is they are telling. The determination of the seat is important as it determines the applicable procedure law and the court with supervisory jurisdiction over the arbitral proceedings. The seat is very important. The court highlighted the importance of party autonomy in choosing the seat. The party to the arbitration has an autonomy. They can select their own seat of arbitration. This is very important. The court clarified that even when parties choose a seat outside India, the courts of that place would have exclusive jurisdiction. Indian courts would not have automatic jurisdiction to interfere in such cases. Now what they are saying here is, we can understand with an example. Here the court is saying that if the seat of arbitration is United States, the law which should be followed is also United States law. So when you are following the United States law, the court of USA has supervisory jurisdiction over you. What is the meaning of supervisory jurisdiction? Meaning that whatever problem you have in the arbitration, you have to go to the United States court. You cannot come to Indian court because you are following the United States law and the seat is the United States. And in the same example, if you have the India as the seat of arbitration, you will follow Indian law. In that arbitration, if you get any problem, you can go to Indian court. This is what they are saying in the judgment. That is told here. The courts of that place, that outside India country, will have exclusive jurisdiction. Indian courts cannot interfere in such cases. The court also said that Part 1 of the Arbitration and Conciliation Act will have no application to international commercial arbitration held outside India. Therefore, such award would only be subject to the jurisdiction of Indian court when the same are sought to be enforced in India according to Part 2. Now, here what they are saying is that, for example, we can take that there is an international commercial arbitration which is held outside India. That is, the seat is outside India. Now, for governing this international arbitration, which court will have jurisdiction? Only the outside court. Out of this arbitration, we get an arbitral award. We get a decision of the arbitrator. Now, for enforcing this award, you can come to India. You can come to India and implement this award. But you cannot go to the Indian court to have section 9 interim measures for getting supportive assistance. For that you cannot come to Indian court. But for enforcing that award, you can come to Indian court. This is being told in the judgment point. Now, by referring to this case law, we got cleared of the concepts of section 2 subsection 2, section 2(1)(f), that is the international commercial arbitration definition, and then we saw what is domestic arbitration, we saw what is international commercial arbitration, and we saw what is the seat of arbitration. Now we are moving forward to the second case law. We also saw about section 9 interim measures. We will be seeing that in detail in the second case law. Here we have a summary for the case law which we saw earlier, Bharat Aluminium and Company. Part 1 of Part 1 arbitration is applicable only to arbitration that take place in India, where the seat is in India. Application for interim order, it is a supportive assistance. You have to go to court where the seat of arbitration is there. When the arbitration takes place outside India, you cannot come for interim order to the court of India. Part 1 and Part 2 are mutually exclusive. There are no intermingling or overlapping provisions in these two parts. The second case law is PISL Wind Solutions versus GE Power Conversion. Here the facts are both are Indian parties. Both the companies are Indian companies. But the seat of arbitration which they chose was in Zurich, Switzerland. Please pardon me, I do not know the perfect pronunciation of the word. So we can keep the Switzerland as the word. The seat of arbitration is chosen as Switzerland. Now, what are the questions the arbitration has? Can two Indian parties choose a foreign seat? Both of the parties are Indian, but they are choosing a foreign seat. Is that valid or not? Whether an application in Section 9 maintainable. Already we saw Section 9 is for interim measures from the court. For supportive assistance, you are coming. This is also a question, whether we can maintain it or not. Is the award a foreign award? That is also a question. For that, we have to read in detail about Section 9 and foreign award. The definition for foreign award is given under section 44. Foreign award in this chapter, that is the chapter 1 New York Convention awards. What is a foreign award? It is an award arising out of legal relationship. It is considered commercial. It is done after this date. These are all not important. The main section starts here. It is made in pursuance of an agreement to which the convention in the first schedule apply. Here they are referring to the arbitration agreement. The arbitration agreement should be there. Following that, there should be an arbitration, and following that arbitration, you should get an award. And for that arbitration agreement, the New York Convention should apply. Second thing, it should be made in the territory outside India, and for that outside India territory, the convention should apply. How you will know whether the convention applies or not? The government will notify in the official gazette. First thing, the arbitration agreement should be there and New York Convention should apply, and the award should be made in the territory outside India where the convention also applies. In simple words, if we analyze the definition, what we are saying is that the award, the seat of arbitration should be outside India. Then the application of foreign law should be made. The arbitration should happen according to the foreign law. The nationality of the parties is not considered. Anywhere in the definition, it is not given that the both parties should be Indian, both parties should be Australian, both parties should be foreign. Like that, no nationality is considered. This is not considered in the definition. Country in which the award made, the convention should apply, New York Convention. So this is also very briefly clarified in the case law for PISL wind solutions. That's why we are seeing this definition. In short, the four things we have to see: seat of arbitration, foreign law whether it is applied or not, and the outside India territory whether the convention applies or not. Previously we saw about foreign award. Now we can see about domestic award. For domestic award, now we can see what is Section 9 in detail. Section 9 is for interim measures from court. You can go to court for getting certain interim measures. What are those measures? For appointment of guardian for minor or unsound person. If there is a minor a party to arbitration, you can appoint a guardian for him. For that, the court, you have to make an application to court. Under which section you will make an application? Under section 9. For interim measure, for preservation of subject matter, securing the amount, preservation or inspection of documents, appointing a receiver, these are all interim measures. Why you are getting these interim measures is that before starting the arbitration, you have a fear that the other party might damage the subject matter, or he may alienate all the assets and he will not have any amount subject matter, or he may alienate all the assets and he will not have any amount to pay to the persons in case the arbitration goes in the unfavorable situation for party. The parties might destroy the documents. For those cases, we have these interim measures. Before arbitration, you can go under this section 9 and you can get these interim measures. After getting the interim measure, you have to start the arbitral proceedings within 90 days. And once the arbitral tribunal is appointed, court will not entertain an application into section 9. Once you have the tribunal, for whatever interim measure you want, you can go to tribunal under section 17. The same measures, but it will be given by tribunal. The section is 17. But after getting the tribunal also, you have to come to section 9 when the remedy under section 17 may not be effective. The court is finding that if the tribunal gives a measure under section 17, if it will not be proper, that it will not be effective. If the court thinks like that, then you can come under section 9 even after the tribunal is appointed. Generally, you should come to section 9 only when the tribunal is not appointed. Once the tribunal is appointed, you have to go to tribunal only. But if the remedy is not effective, you can come to the court also. One more important thing here you have to see is that section 9 comes under part 1. Part 1 applies only where the place of arbitration is in India. So this is where it is given. This is given under section 2 subsection 2, scope of part 1. Previously we saw about foreign award. Now we can see about domestic award. For domestic award, the definition is given under part 1, section 2, subsection 7. An arbitral award made under this part shall be considered as a domestic award. That is, by meaning, what it is saying is that part 1 of the Arbitration Act is a part, and in that part we are getting section 2, subsection 2, 7. Any award made under part 1, it is a domestic award. This is given under the section 2, subsection 7 definition. Now we saw what is a domestic award and what is a foreign award. Now we can go back to the case law. Before that, we have to see the proviso for section 2 subsection 2. This we did not read in the earlier case law. Provided that subject to an agreement to the contrary, provisions of section 9, 27 and 37(1)(b and 37(3) shall also apply to international commercial arbitration. Now what they are saying here, generally part 1 will apply only to arbitration where the place of arbitration is in India. But there are certain special sections. For those sections, international commercial arbitration also, the part 1 will apply even if the place of arbitration is outside India and an arbitral award made is enforceable under part 2. For example, we can take that we want section 9 interim measures. The arbitration type is international commercial arbitration or domestic arbitration. The place of arbitration, the seat, that is outside India. Now, what they are telling is that the seat is outside India, so you cannot come to Indian court for getting section 9 interim measures. But by this proviso, they are telling that even if the seat is outside India, you can come to India for section 9 relief. This is given in the section 2 subsection 2 proviso. Now, based on these definitions, we can come to a conclusion. Now, what is a domestic arbitration? Where both the parties are Indian parties. Now, what is an international commercial arbitration? One party is a foreign in the proviso. Now, based on these definitions, we can come to a conclusion. Now, what is a domestic arbitration? Where both the parties are Indian parties. Now, what is an international commercial arbitration? One party is a foreign party. Now, this is based on the nationality of the parties. Okay, now what if the domestic award and foreign award? It does not have any relation with the type of arbitration. This has the main concern is seat. Where the seat is, that determines the type of award. If the seat is in India, it is a domestic award. If the seat is outside India, it is a foreign award. Under section 44. A domestic award will be given under part 1. When you apply part 1, the arbitration award which comes out is domestic award, and if you comply with the conditions of section 44, the award will be a foreign award. For under section 44, the main condition is seat should be outside India. This is the main condition. And in international arbitration also, where the seat is in India, it is a domestic award. Where the seat is outside India, it is a foreign award. The same thing, domestic award under part 1. You will apply the provisions of part 1 and the award will be domestic award. Foreign award will also be under section 44. Now we can come to a summary that domestic and international arbitration, the type of arbitration, this is based on nationality, whether the parties are Indian or not. But the type of award is based on territoriality. It is based on the seat of arbitration. Where the seat is, that defines the type of the award. Now we can answer the questions. Can two Indian parties choose a foreign seat? When it's two Indian parties, it is a domestic arbitration. Now when they are choosing a foreign seat, the award will be a foreign award. There is no relation between these two. We need not overlap these two or mingle these two. This is also given under the judgment. Two Indian parties can choose a foreign seat. Court upheld the concept of party autonomy. The parties can make the seat according to their wish. This is the party autonomy. Since they have this flexibility, many people are choosing arbitration. And the next question is application under section 9 maintainable. And in the proviso for section 2 subsection 2, we saw that even international commercial arbitration, even where the place is outside India, we can make an application under section 9 to Indian court. Here we can see that it was inserted by amendment in 2015. Now in that there are two types of interpretation. I will show you in the definition itself. Now we have the definition. In that there is one type of interpretation. The first type is that since the word international commercial arbitration is used, these three special sections can come to Indian court for only where the arbitration one party is foreign. This is the definition of international commercial arbitration. Where one party is foreign, it is an international commercial arbitration. Now we have the definition here. There are two types of interpretation for this definition. We will see it one by one. First thing is, while reading it in a plain manner, we can say that part 1 will apply only where the place of arbitration is in India, and these are the sections which will apply even where the place of arbitration is outside India, but the arbitration has to be international commercial arbitration. This is the plain meaning that we get when we read this section. Provided that subject to an agreement to the contrary, these sections will also apply to an international commercial arbitration, even if the place of arbitration is outside India. This is the meaning of the section 2 subsection 2. This is called the first interpretation, and we are going to see the problem in the first interpretation. For example, if we are going to get an interim relief from an Indian court under section 9, now we can get this interim relief only if the seat of arbitration is in India, because section 9 is in part 1 and part 1 will apply only when the place of arbitration is in India. Simply section 9 we can get only when the seat of arbitration is in India. This is given under this section. Now the proviso is telling that you can get section 9 relief even when the seat of arbitration is outside India, but the arbitration has to be international commercial arbitration. This is told by the proviso. In this we have a problem. no relief under section 9 we can get for what? Domestic arbitration with the seat outside India, because the proviso applies only to international arbitration with outside India seat. It will not apply to domestic arbitration with outside India seat. This is the problem in the first interpretation. Now we are going to see the second interpretation. The second interpretation is that in this proviso, if we notice carefully, we can say that the stress is given from this place, even if the place of arbitration is outside India. The main point in the proviso is that these section will apply where the place of arbitration is outside India. Here they are giving the word international commercial arbitration before the sentence, meaning that the international commercial arbitration is not as per the definition given under section 2 subsection 1 clause F. It is not given as per that definition. It is given in the common sense that while drafting this definition, they have used the common sense that if the place of arbitration is outside India, it is an international commercial arbitration. In that sense, they have used. They are not literally meaning the 2(1)(f) the definition of international commercial arbitration. By this way, we can get a harmonious interpretation. By that, we can give effect for the proviso in a very broader manner. The interim relief from Indian court, generally it will be available where the seat of arbitration is in India. But this proviso tells that in certain sections, section 9, 27, those 3 sections or 4 sections, you can get the relief even if the seat of arbitration is outside India, whether it be domestic arbitration or international arbitration. For both the type of arbitration, if the seat is outside India, you can get the relief under section 9 from an Indian court. Now we can see the answer to the question whether section 9 interim relief application is maintainable or not. Here the court has taken the broader stance, that is they have accepted the second interpretation. What they are telling is that proviso to section 2 subsection 2 allows this. What is they are telling is that the word international commercial arbitration used in section 2 subsection 2 is used to refer the arbitration seated outside India. It is used in a common sense manner, not directly referring to the definition in section 2(1)(f). Now, this will give a harmonious interpretation and the court has chosen this. The next question is that, is the award a foreign award? For earlier also we saw, for determining foreign award, what and all we will see. What is the seat of arbitration? It should be outside India. What is the law applied? It should be according to foreign law. What is the territory? In that territory, the New York Convention should apply. These 3 conditions you should check, and you should not check the nationality of the parties. Nationality of the parties should not be checked for determining the type of the award. So, here we have no problem and this will be a foreign award. Just because both are Indian parties here, it does not mean that we cannot say this as a foreign award. All the conditions for foreign award are satisfied. So, this is a foreign award. Because section 44 is a seat-centric provision. The seat should be outside India, foreign law should be done, and New York Convention should apply to the arbitral award. It is not a party-centric provision. It is not checking whether the nationality of the parties is Indian or American. Now, by using these case laws, we have understood certain sections. Section 2, subsection 2 and its proviso, Section 9 interim measures, 2(1)(f) international commercial arbitration, 44 foreign award, what is domestic arbitration, what is international arbitration, what is a domestic award, what is a foreign award, what is the seat of arbitration concept. All this we have completed and we have understood it in a very deeper manner. For that, we have to rank all these case laws also. This is very important in the arbitration concept. You may get questions from this during the exams. So, even if you do not get questions, this is very useful for the Arbitration Act.